Thank you for listening to this PYA webinar recast. PYA is pleased to offer this alternative way to access our thought leadership. This is a recording of a previously delivered webinar. The information is accurate as of the date of the original event. The video recording, slides, and associated material for this and all PYA webinars are available on our website at pyapc.com. This podcast is for educational purposes only. It is not intended to be used as legal advice or an official opinion.
Good morning, everyone. Welcome to the latest episode of PYA's Healthcare Regulatory Roundup webinar series. Today's topic is the American Relief Act 2025. PYA is happy to present today's webinar on this important topic. With that, I would like to introduce our presenters, Martie Ross and Kathy Reep.
Thank you, Jennifer. Good morning, everyone. Thank you for joining us for the first Healthcare Regulatory Roundup webinar of 2025. Well, what a topic we have ahead of us today. I'm going to take you back to early December 2024. Kathy and I were discussing the webinar schedule for January, and we knew that the first webinar would need to address the consolidated appropriations package that Congress was expected to pass at the end of the year. We knew that we had an absolute December 20 deadline, as that was when the government would shut down absent appropriations action by Congress. And so we set this date.
That's all we knew.
Well, that's all we knew, truly. That's all we knew at that point. So like, okay, we'll talk about something on January 15th. So we get to the week before Christmas, December 18th, and we have an announcement that a compromise has been reached. There's a piece of legislation moving forward, and that several of the topics of interest to healthcare providers were addressed in that compromise package. And favorably, we saw a number of one-year extensions of programs, which is what we've become used to, and sometimes the best we can hope. And that bill seemed to be on a fast track towards passage and signature by the president. And then Elon Musk jumped on X and said, I don't like this bill. It spends too much, and I think that Congress needs to go back to work and start over. And soon thereafter, you had President-elect Trump join that chorus. And so a bill that was ready to go was off the table. And in very, very short order, literally a number of hours, we came up with a new piece of legislation. To say a skinny version is making skinny sound fat. This is so thin. And that is the American Relief Act 2025, which passed early in the morning, I believe, on the 21st. So actually we had a few seconds shutdown and then was signed into law. Just for comparison's sake, last year, Consolidated Appropriations Act 2024, which actually came to us in two parts, two bills passed in March of 2024. The first section of that bill was 466 pages, followed by another 401 pages. By comparison, the print of the American Relief Act 2025 is a whopping 51 pages long, of which 7 pages cover the entirety of the healthcare provisions in that legislation. So what we're going to do today is to highlight what's there. Actually, Kathy and I contemplated a dramatic reading of the entire bill to take up the hour we had to speak with you today, but luckily for you,
I couldn't say Karen very well.
Exactly, but we just gave it up. So we're going to talk about those provisions. We're going to talk about now what happens, given that most of the relief we were afforded expires March 31, and as Kathy will discuss, maybe even earlier than March 31. But then we'll talk about sort of where we stand here at the beginning of the second Trump administration, beginning on Monday, and what we can anticipate. Kathy and I are not big crystal ball folks, but we'll give you some idea of what we think is on the table at least. And then with our extra time, we thought we'd cover some other developments of interest, which include the Medicare Advantage proposed rule and advance notice, those proposed changes to the HIPAA security rule that snuck out before the end of the year in 2024, and then this new Consumer Financial Protection Board final rule on medical debt. I never thought I would be doing a webinar on the Consumer Financial Protection Board, but here we are. So those are our topics for the day. Let's start with ARA 2025. Okay, just for context, the same week we had the, shall we say, the big bill going, they released the annual healthcare expenditure report. So this is just for context of what the healthcare industry has grown into through 2023. So overall healthcare expenditures grew by 7.5% to $4.9 trillion annually, or just shy of $15,000 per head. We sit now at 17.6% of GDP. That is only going upward. There's predictions that by 2030, that's going to be right at 20%. 1 out of every $5 spent on healthcare in this country. So if you're talking about right-sizing government, reducing spending, jump-starting the economy, you cannot ignore healthcare. And part of our issue, however, is a significant chunks of healthcare are mandatory spending. So we pay the bill when the bill comes in. That includes Medicare spending, which grew by over 8% in 2023. It is now 21% of the overall healthcare spend in the United States. Medicaid's not far behind. That combination of federal and state dollars, it sits at 18%. Private health insurance is sitting at 30%. And then what we pay out of pocket, still 10%. Then you finally see here how you segregate that by industry segment. You see hospital expenditures still top out at the highest at $1.52 trillion. Physicians are about 2/3 of that, at just shy of $1 trillion. Sorry, it's a B, it's a T, and it's an M. I always get them confused, but that's just shy of $1 trillion. And prescription drug spending is at right at $500 billion in 2023. Again, we expect these numbers were higher in 2024. We'll wait to see. But this is context, right? You can't deal with the economy without dealing with healthcare, given its size and impact overall. So Kathy, with that, what did Congress do in light of that?
Well, on those 4 pages, we didn't get a lot. And there were things that, because of that big bill that we had seen, we were thinking there was going to be a lot of meat in here and a lot of things to talk about. And then they just started whacking away. So essentially, and we're going to talk about this March 31 date at the end of this slide, but we have a 3-month extension on a number of provisions that we have had in place. And it's just to tide us over until Congress does something else. But for the low volume hospitals and the Medicare dependent hospitals, they continued those programs and the current payment methodologies for those programs. The add-on payments for ambulance services, that's the 3% add-on for rural ambulance providers, 2% for urban, and I think it's over 22% for the super rural providers. Those are continuing, again, only until March 31st, so be careful. We don't know what's going to come after that. From the physician perspective, the calculation of the work GPCI, the Geographic Practice Cost Index, under the Medicare physician fee schedule, they kept that in place. That was the floor, the 1% floor predominantly applying to rural hospitals. Acute hospital at home waivers, they again are going to continue, again, March 31st. And we got another push down the road for the expected over 4 years, $32 billion reduction in Medicaid disproportionate share. This was actually, it was going to be $8 billion a year. This has been pushed for year after year after year from when it was originally intended. It needs to be either wiped out or wiped out. There were also some provisions related to graduate medical education, the extension again until March 31st. Now, the reason I say this is a tricky date is because these programs have been extended until March 31st. However, as far as government funding goes, I think Martie mentioned that we were looking at December 20th as being the day we ran out of money and that the government would shut down. Well, now we're looking not at March 31 as the day the government would shut down if there is not funding, but it's March 14th. So literally yesterday, Martie and I were talking about a webinar that we want to do for y'all at the end of March, talking about what all they included in that March 31 packet. What we're going to have to look at as well is what is going on as of March 14th. Are they going to push things further down the road and just do a little, short term, or are we actually going to see that March 31 legislation happen mid-March?
One other topic that was included in the American Relief Act was the extension of the Medicare telehealth coverage waivers. We did not forget, we just wanted to take a deeper dive on this. The original bill had extended the pandemic waivers through the end of 2025. Again, the short bill only goes through March 31st of this year. So where do we stand today? Because this becomes very confusing because you have the overlay of the work that CMS did in the 2025 Medicare Physician Fee Schedule Final Rule, and then you have where we are now through the end of March. So where this all originates, this whole issue originates in Section 1834M of the Social Security Act, which defines the Medicare coverage benefit for telehealth services. And as you'll recall, there were a number of restrictions in that statutory provision for coverage, most significant of which are referred to as the geographic and originating site restrictions. This means pre-pandemic, we only had Medicare coverage if the beneficiary was physically present at a facility, such as a hospital or an FQHC or an RHC. They were physically present at the facility, located in a rural area at the time the services are delivered. So geographic has to be rural, originating site has to be physically present at a facility. Not surprising, utilization of telehealth prior to the pandemic was barely a blip on the screen. Congress steps in, if you remember, March 2020. I can't believe that's almost 5 years ago now, but they step in and say, we're going to waive those restrictions for the duration of the public health emergency. And so we saw an incredible spike in telehealth utilization, which has continued. About the most recent report, I think, showed about 24% of all Medicare beneficiaries receive at least one telehealth service a year. As of, I think the most recent report was now released is October 2024 data. One thing Congress did do in 2021 in a massive end of the year legislation, I had to go back, the Consolidated Appropriations Act of 2021 was a mere 4,100 pages long. So, but obviously we were dealing with a lot of pandemic issues back then at the end of 2020. But as one of those many provisions in the CAA 21, Congress made permanent the exception from the geographic and originating site restrictions for telebehavioral health services. So regardless of what happens on March 14th, 15th, or through the 31st, there will continue to be coverage for telebehavioral health services offered regardless of location, in a patient's home, urban area, it doesn't matter. What will become effective on April 1 is the requirement that there must be an in-person visit within 6 months prior to the initiation of telebehavioral health services for newly initiated services. If you are already providing telebehavioral health services to an individual, there's no need to have a run into the office so I can see you face to face to continue to providing the services. No, it's only the new initiation of services, and we'll see that requirement go online then on April 1st, absent any other action. The other component of these extensions that were critical was expanding the list of telehealth providers. Again, going back to 1834M, it specifies that only physicians and non-physician practitioners can be reimbursed for telehealth services. Again, through a series of legislation during the pandemic, Congress expanded that out to effectively any individual or group practice that can bill under the Medicare physician fee schedule can bill for telehealth services. So that included the therapists, the clinical psychologists, and the like. That provision, allowing that extended range of telehealth providers, again, remains in effect through March 31st. But again, skinnies back down absent congressional action by April 1st. Then, because the statute only says physicians and non-physician practitioners, the assumption had been that RHCs and rural health clinics and federally qualified health centers could not be reimbursed for telehealth services. Again, pandemic, we waive that requirement. CMS creates a methodology to pay rural health clinics and federally qualified health centers for telehealth services. In the ARA, Congress extended that authority for RHCs and FQHCs to be distant site providers, i.e. bill for Medicare telehealth services. It's interesting though, here's where we get that overlay with the final rule, because CMS in the final rule amended 42 CFR 405.2464, which is the provision that provides for payment to RHCs and FQHCs, and effectively made permanent through regulation the ability of RHCs and FQHCs to get paid for telehealth services. They're paid at an average average reimbursement rate, as opposed to their error rate or their PPS. But that methodology appears in the statute to go forward. So that's one of those questions I have. If we reach April 1st, will in fact RHCs and FQHCs be able to continue to submit claims? By the regulation, it appears that they can. Finally, we have the issue of audio-only telehealth services. Again, authorized by the statute, but you have to look at what CMS did in the 2025 final rule. There, they added a provision in 42 CFR 410.78 to define the statutory language, which is interactive communications technology. It defined that to mean audio-visual, except in circumstances where three things are true. First, that the patient is physically present at their home at the time the service is delivered. Second, the practitioner, the provider delivering the service has the capability to do audio-visual. And third, the patient either does not have the capability for audio-visual or they do not consent to visual. If those circumstances are true, then you can provide telehealth services via audio only. If that is not true, it needs to be audio-visual. That's a shift, because what we had at the end of 2024, when you took a look at that list of approved telehealth services, there was a column that said, is audio interactives alone sufficient? The wording is a little different than that, but that's what it meant. And there would be the no, 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 yes, 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 as you listed every, a CPT HCPCS code that's on the approved list. You'd look at that column, and that column would tell you whether you could provide that service audio only or required audio visual. If you look at the list for 2025, that column's gone, because CMS said it is no longer tied to the specific service, whether that will be reimbursed if it's audio only. Instead, any service potentially can be audio only, but only if those three things are true, right? Okay. Patient at home, provider capability, no consent or capability on the part of the patient. In those instances, you would bill the service with an 83 modifier. RHCs and FQHCs use the FQ modifier. Again, CMS has eliminated the audio only E&M codes. Those are no longer reimbursable. It did not adopt the set of CPT editorial board codes for telehealth services. They didn't adopt those, instead opted for this audio only approach they use. That, of course, is going to change with the coverage for services. That doesn't impact coverage. It just tells you the manner of delivery of the services. So to say that things are just a tad confusing right now when it comes to Medicare telehealth coverage may be a little bit of an understatement, but I appreciate that we are in a holding pattern for the primary issue of coverage, which is geographic and originating site. Now, interesting conversations we've had with folks around this. They're like, well, this is definitely going to go. Oh, definitely extend
Martie,
further.
what was in the December 18th related to telehealth?
Right, it would have been December 31st, 2025. So they whacked out.
Only a 1-year extension.
Only a 1-year extension. We had hoped for 2, we got 1. And folks are sort of presuming that the bill that comes up will have the further extension. The issue you have, we've discussed this previously on this webinar series, is you've got a Congressional Budget Office that scores the telehealth expansion, as they call it, at $4 billion over 2 years. And so you got to come up with the money. Congress has to find a way to finance this expansion given the CBO's score. And certainly, as we're going to talk about, we're going to be in a cost-cutting mode, at least early in the Trump administration. So finding, a spare $4 billion somewhere to finance this may, in fact, be challenging. Then, of course, there's also the argument that CBO is off its rocker. That's sort of tough, isn't it? Maybe CBO is using a methodology I would not agree with. There we go, they're off their rocker, right? But they say that telehealth services cost so much because they're additive. So we're already paying for this many in-person visits. If we include an expansion of telehealth, we're adding more cost to the system. So that's how they get to their $4 billion price tag. Interestingly, if you go over to CMS, when CMS is calculating the conversion factor under the 2025 fee schedule, they're saying, well, we know that telehealth is likely to go away. I mean, it is going away right now. Our assumption in building our model has to be that there is no coverage in 2025. But we don't think that matters because we just think people are going to go, instead of receiving telehealth services, they're just going to go in person. So you've got two ways of looking at this, one of which is the obstacle to expansion of telehealth services because of CBO scoring this and Congress having to come up with the cash. So a little deeper dive on that front, but it is certainly an interesting area. If you are folks with the vested interest in this, it's certainly important to be your voice being heard as to the importance of telehealth services moving forward. It continues to be out there.
So when we look at that big bill that was out there December 18th, that then got whittled down to 4 pages as it relates to healthcare. What was in that, in addition to that extension of telehealth coverage as we know it right now through the end of December? First of all, a very important item was that they were going to adjust the current reduction in the physician fee schedule, the conversion factor. And we have a reduction of 2.83% for 2025 based upon what CMS did. Congress was stepping in and they were modifying this so that it wasn't as big of a reduction. There was still a reduction. The other thing that we just want to remind you of, because we know we've got people who are very concerned about the physician fee schedule and then others who think it doesn't mean anything to me. Recognize that if you are a hospital and you provide outpatient PT, physical therapy, speech pathology, occupational therapy, or mammography services, those are paid under the physician fee schedule. So if you are seeing that 2.83% reduction in the conversion factor for physician services, you're also seeing it for your mammography services and your outpatient therapies. So recognize we need Congress to step in. They did, but that got knocked out of the final bill.
It'll be interesting, Kathy, because we had the same issue last year. And what happened is Congress stepped in March and said, we'll provide a 2.83% bump for 1 year. Well, not even a year, just through the end of December. And it was not retrospective. Right. So we had 2 fee schedules. We had 24A and 24B because the services provided before March 7th were paid at that lower 2.83% less. We get to this issue because Congress had only provided a 1-year extension of that payment increase. And so come January 1st, that was gone. That's why we ended up with the cut in the conversion factor.
So again, something that we need to see, Congress was stepping up and they were fixing it, but that got knocked out. For alternative payment systems, alternative payment models, the advanced APMs, the incentive payments that were targeted to be 3.53% for performance year 2025, which would actually been 2027 payment year, that was included. It is not in the final bill that we have right now. Something that was rather scary and that maybe we don't want included in the final bill, or actually we definitely don't. It's not there now. It was in the one that didn't pass, but this was legislation that would have required a separate national provider identifier and attestation by an executive within the hospital for any off-campus hospital outpatient departments. So that was struck from the final bill, but recognize that this could very easily come back because it has been passed in both the House and the Senate over the last 2 years. Site neutral payment for drug administration. This is essentially saying if you have drugs that are, drug administration that is done in an off-campus outpatient setting, it would pay as if it was provided in a physician office. That was included. It's not in the final. Is it coming back? And then lots of changes related to pharmacy benefit managers and the regulations there. I think it's a little bit detailed to go into right now, but just recognize that this was something that was there. They were starting to tackle what they perceived as an issue, but again, it got dropped. So will we get these? Will we get a physician fix? Will we get the incentive payment? And hopefully we will not get the separate attestation and NPI number for off-campus, or have to face that off-campus drug administration issue as well.
The other thing out there that never made it to the big bill, so this was not in the compromise, there had been, as Kathy has discussed previously, there have been a whole bunch of provisions around price transparency.
Oh, yeah.
That passed both the House and the Senate, and that was part of what fell on the cutting room floor before the bill on December 18th. So we'll see if that one comes back as well, but they were just trying to, the first level of trying to streamline it. Those provisions fell out. We'll see what happens there from that. So that gets us to.
Remember that the executive order that has us where we are right now was under the first Trump administration.
Right. So here's a scary slide. So now what? As I said, Kathy and I, our crystal balls are very cloudy, but we're just going to talk about some of the practical issues that come into play here as we move forward with the new administration. You've probably heard this term, one big beautiful bill, also taken from do you call them tweets, even though it's now X? No one's ever answered that for me, but it was a tweet by President-elect Trump, there we go, that he was asking Speaker Johnson to move forward with one big beautiful bill that would be focused around the priorities from the campaign. And the vehicle to accomplish that bill is budget reconciliation. And the reason we love or hate, depending on where you stand, the budget reconciliation process is because it is the one way to get around the Senate filibuster rules. The process, which goes back into the 80s, is a provision that allows Congress to make adjustments to the budget. So a budget reconciliation process is based on a budget resolution that comes out of committee. It directs what can be included in the reconciliation bill. The test is it has to be something that impacts the budget. So its primary purpose is to resolve budget related issues. So there is certainly, and then we've had a number of pieces of legislation over the years that have used the budget reconciliation process, typically because you've got a party in power, particularly in both houses, but they can't beat the filibuster. And that's where we stand at, 53-47. So that's the interest here in getting the big, beautiful bill under budget reconciliation process. What do we know that's going to be in there? I mean, the top priority, as we understand, is the extension of the 2017 tax cuts, which are set to expire later this year, as well as making good on candidate Trump's promise to eliminate federal tax on tips. Also, what will go in here, most likely, is the debt ceiling. Going back to what we saw at the end of December, what President Trump was particularly interested in this final, what became the American Relief Act, was to include a provision that would have extended the debt ceiling, which would again allow the federal government to continue borrowing money, not default on its debts and obligations. And we've heard the debt ceiling debate. It's gone on for a number of years now, keep increasing the amount. What understandably President-elect Trump wanted was to have that issue resolved prior to taking office and not have to go through a debate around the debt ceiling, because the expectation is you need Democratic votes to get that done. And the Democrats wanted to hold that as leverage for future negotiations. So they were not interested in including the debt ceiling in this final package that went forward. What's very interesting is that you saw the pressure from the incoming administration on the Republicans to pass this legislation. And what we ended up with was the debt ceiling provision not in that bill. And you had the pressure from, again, a group of about 35 Republicans in the House who objected. They said they want to separately debate the debt ceiling because they see it as an opportunity, again, to argue in favor of reductions in government spending. So that's interesting because we've had you've got a very close majority right now in the House, closer than it was before the election. I think it's 1 vote difference right now, but it could go back. It's 3 now, could go back up to 5, which is 5 is where we were before the election. So you have to wrangle your people carefully. To have 35 Republicans who have already said, no, we disagree with the administration, we're not going to include this in the legislation, creates a pretty interesting dynamic going forward, one which we will watch closely. So, but at some point we have to deal with the debt ceiling or default on our obligations, which we can only imagine what that would do to the global economy. The other priority in this budget reconciliation process is border security and all of the issues related to immigration. There have also been mention of energy to expand drilling, defense to increase defense spending as appropriate. And then you're kind of having this general conversation around spending cuts focused on mandatory spending. And mandatory spending is the entitlement programs, Medicare, Medicaid, Social Security. But what you're hearing from Speaker Johnson, this is his quote, "We will not cut Medicare benefits, quote, in any way or anything."
But that's benefits to the patient.
Bingo, exactly. So the question is, what does that do to provider payments? That's why we have these concerns around telehealth. We have these concerns about the physician fee schedule, because all of those carry dollars with them. And if you're trying to cut trillions out of the federal budget, it makes a difficult case trying to make this forward. In the context of the reconciliation process, appreciate this thing called the Byrd Rule. Good old Senator Byrd from West Virginia. It requires that a reconciliation bill cannot affect the Social Security program. So there is no opportunity to cut Social Security through this reconciliation package. That again is leaving Medicare and Medicaid out there as the targets for potential mandatory spending. They've said they won't cut Medicare benefits. They have not said the same with respect to Medicaid benefits. So we'll leave that as it is. The other element of the Byrd Rule is you cannot add to the deficit for more than 10 years. That's why, for example, the original Trump tax cuts was sunset when they did, which would be later this year, is because of the 10-year rule on the deficit reduction. So that's the other restraint that we're dealing with in all of this. The commitment by Speaker Johnson is to have a bill on the president's desk by Memorial Day, which to me says this eats up all the oxygen in the room for the first several months of the 119th Congress. How exactly do we get the extension
March 14th
on
and March 21st.
Exactly. And then how, yeah, that issue, like, oh, we're running out of money too.
Yeah.
But how do we get the attention of healthcare? You know, again, despite the fact it's now 18% of our GDP, is how is this line up and have the attention we need in the provider community moving forward? Kathy? Oh, is this me or you?
It's both of us.
Okay. So what do we think they are going to do at some point in the 119th Congress? I mean, we will live past Memorial Day. What do we think they're going to look at? I think first on the list, we're going to see price transparency legislation, no doubt. More requirements, more penalties.
Transparency, ASCs, labs, et cetera, absolutely.
It looks like you're doing something and it doesn't cost anything, right? I mean, that's kind of the perfect.
Well, it doesn't cost them anything.
Exactly. Cost us a lot, but cost them like, the Medicare Advantage debate is going to be fascinating because you've got the provider community and you've got more of the general public concerned about Medicare Advantage plans and prior authorizations and denials, and kind of Medicare Advantage is getting the same negative publicity that commercial insurance is generally, sort of that reaction to the assassination of the United Healthcare executive and the public response to that. Very difficult to read those tea leaves. But at the same time, you've got Dr. Oz, our presumptive CMS administrator, who has said publicly, I think Medicare Advantage is great. I think federal government needs to get out of Medicare. Okay, sorry.
You should automatically be enrolled in Medicare Advantage, and then if you don't want that, you have to opt in.
He has floated that. It will be interesting to see where that goes. Obviously, that would require legislation. So it'll be very interesting to see where the Medicare Advantage debate goes. We will have something that looks like ACA repeal, or at least is labeled ACA repeal. I think what that means is we're going to see the reemergence of limited benefit insurance coverage. That's on behalf of every hospital and clinic administrator, because what you end up with is health insurance that is pretty much only catastrophic, but people think they have insurance, right? And so we'll see be prepared, and it's something where we really need to be educating folks about limited benefit really means limited benefit. Probably more noise going on drug pricing. The progress that has been made to date, will we continue expanding out that list of medications for drug pricing negotiations? The 340B program, I worry that this becomes leverage in the PBM debate. Is that they'll regulate PBMs, but they'll give them what they want under 340B, which of course would be devastating for many of our safety net providers that really depend on 340B revenue. There's the opioid epidemic. Fentanyl is a synthetic opioid, so it falls under this as well. Again, highlighted as a real concern for President-elect Trump, and what we'll see around potential dollars going in to solve the issue or new restrictions placed on the usage of opioids. The AI debate, need I say more? How do you regulate AI and prevent it from becoming super intelligence that takes us all over? That's another story. Near and dear to our little rural hearts is the Rural Emergency Hospital Program, some modifications to that program to make it more appealing, such as 340B status, swing beds, those really obstacles to many hospitals doing the conversion that otherwise would make sense for them. We'll see if we have legislative solutions then. And then these last two bullets are more general, sort of how does this generally affect what's going to happen with healthcare in Washington generally. You have Robert Kennedy Jr.'s Make America Healthy Again agenda and how that will roll out. There are some real concerns that there are going to be parts of HHS that may go away or be subsumed into other parts of agencies, such as the Agency for Healthcare Research and Quality, which has been a target previously. Do we see that either rolling into NIH, rolling over to HRSA? So there could be some changes. Certainly what's going to go on at FDA, that will be interesting to watch and how that impacts us going forward. And then you have the DOGE. Yes, Kathy, I called it the DOGE, even though I want to call it DOGGY, because I think that's a better pronunciation of the acronym. But the Department of Government Efficiency, which is not really a department. It is a, what's the word? I want to say shadow, but I don't want to use the word shadow, but it is a non-governmental task force that is looking into agency operations to identify waste and make recommendations to Congress as to eliminating waste in federal agencies. This is sort of this target of, this is the Elon Musk initiative where he wants to eliminate $2 trillion. And that's beyond what he wants to do with mandatory spending. But what recommendations we'll see coming out of that, certainly something worth watching, definitely.
One thing we didn't include on that list, Marty, that is huge is the No Surprises Act. Because we're going to, first of all, we're still dealing with lots and lots of interim rules, interim final rules. We've actually got a proposed rule that we have no action on yet. And we've got litigation and so we're going to have to address No Surprises Act as well. Going on to, okay, so we're going to talk about some rules that have just been published and things like that. So what happens with these things that happened under the current administration when we move into a new administration on Monday? Essentially did some research figuring out what does happen next. And so there's several options that are out there for rules that have already gotten through the notice and comment rulemaking. They are final rules, okay? And their effective date is out there and is passed. First of all, those could actually be delayed in terms of, but in terms of the effective date, it could be delayed, but it would have to be published in the Federal Register that they are going to delay implementation of a particular rule. What could we be looking at there? Nursing home staffing levels, huge. That could actually even be turned around and, totally repealed, absolutely. HIPAA reproductive rights, what will be the status there? Some of the provisions related to 1557. Again, we've got a lot of litigation around that one. Will the administration step in and modify the rule? Anything that was finalized after August 1st of 24 can actually be rescinded by Congress. They can say, no, we don't want to do this. So next step, we got that one. There could be a moratorium on those rules that are not yet in effect. So we're going to talk in a little bit about the rule from the CFPB, the Consumer Financial Protection Bureau. That could be delayed from an effective date perspective. It gives the new administration some time to review what's been included and to think about it. So that would be an opportunity there. We got a lot of guidance documents that are out there. Those could actually be repealed or amended. There would not be a notice and comment provision related to those. That only is going to apply to something that was published in the Federal Register. We've got proposed rules that we're dealing with right and left. We're going to talk about the HIPAA security rule. Could they put a moratorium on rules that are under development? We've got the Medicare Advantage, the Part D rule. Will they delay implementation, or will they delay the publication of a final rule? So we don't know what's going to happen, but there are a lot of opportunities under the Congressional Review Act that allows them to the new administration to modify what was done under the prior administration.
Stay tuned.
That's fun.
Stay tuned.
So with that,
well, we've got 15 minutes of quality time with you all, so we want to cover 3 other regulatory developments, starting with what's up with Medicare Advantage and the proposed rules and the advance notice that have been published by CMS. So Kathy, you want to start talking about the 24 rule, because that kind of provides us some perspective on what now is happening with the 26 rule.
Sure, and I'm just going to be very, very quick on the 24 rule because it was effective last year, okay? We should be following this. Actually, I should say the Medicare Advantage plans should be following this rule now. And this related to compliance with traditional Medicare policies related to national coverage determinations, the local coverage determinations, coverage and benefits. The areas that we have seen the biggest, I'm going to use the word non-compliance with, relates to the inpatient only list and the 2-midnight benchmark. We have seen that the plans have, no, I don't really think that's an inpatient. Let's make it observation. So there has been a little bit of a reduction in the plan's use of observation, long stay observations, but very minimal. So recognize that this continues to be an issue that needs to be addressed in regulation again. And if the plan it wants to develop its own internal coverage criteria for something that does not have criteria under the fee-for-service Medicare program, they must use actual clinical evidence related to the policy that they're creating. They've got to be able to cite, where did I get this information? And it's not from Dr. Brown, who thinks it's a good idea. It's from the American Society of that, the specialty, so that they are actually making sure that the information is truly a good clinical recommendation. That information has to be made publicly available, publicly accessible. I can find it, even if I'm not a part of that plan. You can find it, even if you're not participating with that particular plan. So recognize that information's got to be out there, and it's got to be able to demonstrate that their policy doesn't cause harm. You have seen slide over and over and over again from Marty and I, but we're just going to keep re-emphasizing that this February 6, 2024 FAQ, that was a document from CMS to the plans themselves, with these were questions that were asked by the plans. What do you mean by? This is so important that you have a copy of it, have it readily available when you are arguing a point made by a plan. Please go back to this letter, cut and paste, because these were the instructions to the plan. As an example, my favorite one is, what do you mean by a local coverage determination? I'm in Florida, can I use the local determination of the MAC in Kansas because it's a local coverage determination? No, local means local. So really scary that they asked that kind of question, but make sure you have this as a provider and are using it as you argue what the plans are trying to impose on you. So now, Marty, what's coming next?
Well, so to CMS's credit, when they imposed these new rules for 2024, they promised that they would do monitoring of plan behavior and that they would use that as a basis for proposing additional changes in 2026, and that's exactly what they did. So this rule, which was published in December, they're still open for comments through January 27, and it revisits many of the same issues that were addressed in the 24 final rule, but goes into more specificity. So it's taking a lot of what's in that guidance document and now bringing it into the actual regulatory text, such as, please, I know it drives everyone crazy, they authorize a procedure and then deny payment on it, or they authorize admission and then deny payment. So that would prohibit. Prior authorization means authorization that we're going to pay for it. Again, tightening up those standards.
Marty, part of this was included in last year's rule.
Yeah, they're just saying we're gonna.
Do you really mean it this time?
Well, they mean, really, when we say local, we mean local. It's sort of what this is. It's really, it sounds redundant in large part because we've been reading it out of the February FAQs. So they are moving forward with this and continue to be serious. Marketing, I think, is some very interesting provisions. If you hate the generic MA plans as much as I do, finally, they are now going to be subject to pre-approval. So previously, you had to mention a particular Medicare Advantage plan or sponsor before you had to go through the pre-approval process. But if you were just generally promoting Medicare Advantage, those ads could say anything they wanted to say because they weren't subject to pre-approval. And now for the 26 plan year, they will be. There are also new requirements for broker disclosures, specifically that brokers now have to inform patients that if you are in traditional Medicare and you move to Medicare Advantage, if you later choose to go back to traditional Medicare, it is likely that you will see a significant increase in your Medicare supplemental costs, or you'll simply be denied coverage by Medicare supplemental plans. So that is intended clearly to highlight finally for seniors that there is a risk when you go into an MA plan, if that plan if you choose to go away from that plan for whatever reason, that it's going to be difficult for you to get back into traditional Medicare because of that additional cost on your Medicare supplemental. They'll now be required to disclose that. There's some changes to expenses that you can include in medical loss ratio, particularly refinements of quality payments made to physicians and other providers, that the MA plan has to make a direct correlation to quality improvement. And then for Part D, the thing that we've all paid attention to is the broader coverage for GLP-1s. Previously, the coverage was limited to individuals that had diabetes, and we're now going to provide coverage for individuals diagnosed with obesity. So a significant expansion, proposed expansion of that Part D coverage. The other piece of the puzzle, and remember, we're on a very strict schedule when it comes to MA, because it all comes to the date that MA plan bids are due, which is June 1st. And those bids are due June 1st because we start marketing the product in October. So you have to meet the plan year requirements. So in addition to that rule that came out in December, which was regulation of plans, we also received earlier this week, what was it? It was last Friday, excuse me. Last Friday, we received the annual advance notice, and this is sort of what CMS proposes to pay to MA plans. Again, comments are due on February 1st, and CMS promises that it will publish the final rate announcement by April 1, which it is required to do. What we saw in the advance notice was a projected net increase of 4.33%. That's $21 billion in plans to MA. That's the overall increase. What's critical? Go ahead.
Docs are getting a 2.83% decrease.
Yeah. Well,
okay.
The real number is 2.23 because that's the increase on the benchmark payments, right? That's the actual increase.
It's still an increase.
Yeah, because in 2025 is a 0.16 reduction. So it is a significant increase, and it could be more, and we'll likely see the plans arguing for more, because how they got to 4.33 is they start with the effective growth rate and then they make adjustments. And the two critical adjustments that drove down the payments to MA plans is the graduate medical education cost adjustment, which has been, CMS has been phasing in now for 2 years. They are making that adjustment to the growth rate to make MA pay its share of graduate medical expense costs. If we did not continue at that phase-in, that would be $7 billion more to the plans. And then we, of course, have the implementation of the 2024 risk adjustment model, which again, phased in over 3 years, with the final year of phasing that in. CMS says if we paused that, it would be another $3.4 billion in payments to MA plans. CMS takes the position that MA programs are stable right now. We have good access to the programs. We have coverage to pay beneficiaries, adequate level of supplemental benefits, that it is not necessary to make this what would be, $10.5 billion in extra payments to the plans. We'll see where the debate goes on that. So pay attention to that. Very interesting. Proposed updates to the HIPAA security rule, which came out end of December. To you, Kathy.
Yeah, this was published on January 6th. Comments are due March 7th. Neither Martie or I are experts on HIPAA security, nor do I think we want to be.
But we got a guy.
But we've got a guy. And so I'll touch on a few things related to this rule, but we're going to tell you at the end about an upcoming webinar by our PYA's very own Barry Mathis, also known as Scary Barry, to really talk about this rule in depth. Comments
only because he was a Marine. That's why we call him Scary Barry. So.
Okay, sure. Never mind. But the security rule was originally published in 2003. It was updated last in 2013. Now 2025, we're looking at some changes. And these changes are going to be significant. And I'm probably also going to say extremely time consuming and costly. Okay, that's the best way I can do it. I've given you on the slide the effective date. Comments due March 7th. There's going to be a final rule that would come out. The effective date would be 60 days after the final rule comes out, but then compliance would be required 180 days following that. Let's go through some of the provisions that are actually out there that they are saying. First of all, we know that with the current security rules, cybersecurity rules, we have certain specs that are required and others that are addressable. let's, according to this rule, eliminate the idea of addressable. Everything is going to be required. Okay, going to eliminate addressable. Let's go with required only. They're going to update definitions that reflect changes in technology and terminology. What we start looking at, or what are we going to define? We're going to define risk. We're going to define threat. We're going to define implement. And we're going to define a number of other words that have been used in the existing rule that need better clarification, apparently, for some individuals. There's going to be the requirement for written documentation of all of your security policies and procedures. There's going to be requirements for vulnerability scanning at least once every 6 months, and penetration testing at least once every 12 months. Development of a asset inventory and network map that is maintained on a at least annual basis. Provision I think is really interesting is that you must have a backup system that would contain exact copies of electronic protected health information that would be would be less than or equal to 48 hours older than the EPHI maintained in your regular electronic health systems. In other words, you're going to have a backup, a current backup of all of your data. You're also going to have to be able to disable an individual's access to within no more than an hour following termination. You're going to have to report on those individuals who have whose access has been changed or terminated. You're going to have written procedures to restore EPHI and data within 72 hours. Encryption required both at rest and in transit. Multi-factor authentication required. Anti-malware protection required. A lot of provisions required on the business associates as well. So recognize huge task ahead of you. Make sure that you have someone within your organization who A, listens to Barry's webinar, B, reads this and comments. Again, comments due in early March.
Yeah,
So
it's a lift when it goes from best practice to regulation. And I think that's exactly where we're going with the HIPAA security rule. Okay, Kathy, wrap us up. Consumer Financial Protection Bureau.
This is one that when we went back to what could the Trump administration do to this, we're going to run into some politics. But the Consumer Financial Protection Bureau issued a rule, final rule that came out in January, that says that a consumer credit reporting agency may not use information that was reported to it related to medical debt in providing a credit score. A lender cannot use medical debt in assessing a borrower. So as a provider, you're going to need to make sure that you are really focused on collections, upfront collections, not the idea of I'll turn it over to a collection agency and people will be concerned about its impact on buying a house, on buying a car, et cetera, because this will be thrown out completely, both by the lender and by the credit reporting agency. The rule says that they expect that this provision, this new rule, would boost credit scores by an average of 20 points for those who have medical debt. This rule, even though it's final, is now being challenged in our friendly Texas federal court. They have said that the Consumer Financial Protection Bureau has overreached with this. The Republicans, who now have control of all branches, have criticized the CFPB. There's no one who will be leading this. No one's been nominated yet. Elon Musk had at one point tweeted, delete CFPB, but it's a voter issue because voters are the individuals who have the medical debt where it's prohibiting them from buying a home, buying a car, etc. So very concerning about what can the administration do with this, when it becomes such a voter concern. Martie?
Well, we've made it to the end. Just to highlight upcoming healthcare regulatory roundup webinars. January 30, that's a Thursday as opposed to usual Wednesday. We're going to do a 90-minute CPE webinar on the team model. Kathy and I have corralled some real experts to talk about some key elements in the team model as the countdown continues to that January 1, 2026 implementation date. On February 12th, I'm going to be joined by Lori Foley to do our annual What's Up with Chronic Care Management and Remote Patient Monitoring. We always do our 2025 updates of our white papers on those subjects, and we'll roll out the details and interesting facts around CCM, RPM, and other types of care management reimbursement. And then, as promised, February 26th, Scary Barry will do a deep dive into the proposed HIPAA security rule, giving you sufficient time to garner your thoughts to submit comments by that March 7th deadline. So Happy New Year, everybody. I'm sure it's going to be interesting, and we look forward to bringing you a healthcare regulatory roundup twice a month.
Thank you for listening to this PYA webinar recast. The video recording, slides, and associated material for this and all PYA webinars are available on our website. If you have any questions or if we can help, please contact us at pyapc.com. Thank you again for joining us, and have a great rest of your day.